Good evening. I extend my appreciation to the Center for Justice and Accountability as I accept the Champion of Justice Award. Thank you very much for this honor. I adhere to the law as a method to sculpt, refine, or reconstruct justice. To me, law is not a foreign object cold to the touch. It is a tool shaped by the warmth of human hands. My personal motivations for becoming a lawyer undoubtedly arise because I'm an African American woman who witnessed the human rights struggle in the United States for civil rights. However, since I was 12, I never seriously considered any other profession. While growing up, the difference is that I had legal heroes, mythic African American legal heroes. There was Paul Robeson, the multilingual, artistic lawyer who understood that every injustice is both national and international. There was Justice Thurgood Marshall, who litigated Brown versus the Board of Education in the year of my birth, and later became a U.S. Supreme Court Justice. And there was Dr. Charles Hamilton Houston at Howard University, whose brilliant legal strategies unpaved the cobblestones that had edified U.S. racial segregation, or what today, as an international lawyer, I would call crimes against humanity of apartheid or persecution. These attorneys submitted legal pleadings on behalf of their individual clients, yet they centered the communities in their legal struggles. They anchored the harms within a broader context of society. Today, this is called strategic litigation. These gifted legal heritage that I was awarded accompanied me into international criminal law. I too would come to understand that justice resides at the nexus of national and international law. Genocide and war crimes in actuality are committed locally, but resound internationally, including acts of sexual and gender-based violence. War-related sexual violence once resided in the public consciousness as something that was inevitable, committed by a few bad apples that curiously were enlisted in every army and militia. Actually, rapes or any type of sexualized violence had been outlawed long before the Yugoslav or Rwandan tribunals were established and prior to the creation of the International Criminal Court. Contrary to urban legal myths, sexual and gender violence, reproductive violence comprise part of the compelling evidence presented at the Nuremberg and the Tokyo tribunals, even though at Tokyo the sexual enslavement of the comfort women was not tried. However, after World War II, the public consciousness retreated and sexual violence became the unmentionable underbelly of armed conflict. Today, we've begun to halt that illusion. Thankfully, no military or political leader today would deem lawful the rapes committed during the Rwanda or Cambodian genocide, the sexualized enslavement inflicted in Sierra Leone or Syria, or the sexual and gender-based violence that will soon be uncovered in the Ukraine. Since the 1990s, the statutes of international courts and national codes have expanded the enumeration of international crimes of sexual and gender-based violence. However, to be effective, laws must be applied. Gender-competent investigations, prosecutions, and adjudication are required prior to the rendering of any justice. Physical and psychological sexualized gender harms must be pursued, or better yet, prevented. How can the public consciousness be prodded even further? Well, I increasingly underscore that the doctrinal spine of international criminal law and humanitarian law aims to protect the international community group by group, by its group formations. To be more precise, you and I, are safeguarded because we have a status as a member of a group, and that these groups make up the international community. For example, the Yazidi girl in Iraq or the Mayan Ishil woman in Guatemala who endured sexualized enslavement as an act of genocide was targeted due to membership in her ethnic or religious group. The Genocide Convention was specifically drafted to protect such groups. Gay men who are publicly executed by ISIS based on their sexual orientation are part of a broader group, the civilian population. Hence, their murders, and probably the recent murders of civilians in the Ukraine, can be charged as crimes against humanity. That is the international crime destined to address widespread or systematic attacks against the civilian population. As members of the international community, we exist as collectivities, whether in states, as citizens, as indigenous societies, as castes, as ethnic, political, or racial groups, as civilians, as children, adults, as soldiers, or as religious persons. Each of these collectivities is per se gendered, consisting of males and females, the young, the old, persons who span gender identities and sexual orientations, and protection of the sexual integrity of all members of the group is a concern and the subject of international law. The sexual or gender violations committed as international crimes really represents an assault on the individual and an assault on the group, the collective, and a tear in the fabric of the international community. That is the wellspring of our concern for the Ukraine, as it must be our consternation too for Yemen, Syria, and the Democratic Republic of Congo. Sexual assault witnesses testify on their own behalf and on behalf of their group. Most significantly, I recognize that they witness for us, the international community. I believe that deeply threaded throughout international criminal law is a strand of the African principle of Ubuntu. I am because you are. Interdependence and compassion must arise, as Ugandan feminist Sylvia Tamale would aver. Ubuntu should further the rendering of justice. To be grounded and contextualized in community permits us to perceive the true scope and the intended horror of sexual and gender-based crimes. It prevents the fallacy of perpetration of separate, unrelated, individualized harms during armed conflict or periods of crimes against humanity or dreadful occurrences of genocide. These communal approaches to law, initially gleaned from my childhood legal heroes, have helped me devise legal strategies for sexual and gender-based violence as international crimes. They have also guided my respect for survivors. Adherence to these principles, while I grip the tool of international criminal law, is the reason that I am here today and that I am able to deeply thank the Center for Justice and Accountability for extending to me such an incredible honor to be recognized as a champion of justice. Thank you.